We are gonna go back on the record.
So you could cut this one at all?
And
McCullough's eating cake.
we have an opportunity to hear from Brian Grearson, who is you're a judge in the environmental court, but you're also the
Chief Superior.
Head honcho. All right, please join us. And welcome.
Thank you for inviting me back. It's encouraging after appearing last year to know that you wanted to hear from me again. I appreciate that. For the record, Brian Grearson, Chief Superior Judge. And I guess I would begin by saying I don't expect everybody to remember my testimony from last year, but certainly in a lot of respects what I had to say about last year's bill would apply to what's before you now. In terms of the court doesn't take a position on whether you should somehow transform the environmental court and go back to the process that existed before the environmental court came into existence. Those are policy decisions, and we respect that's the prerogative of the legislature and not the judiciary. What I will try to do is to explain the potential impact on changes that you are considering, and that's the best way I think I can help this committee. In that regard, I know that there are differences in the bill. I guess it's not really in bill form yet, is it? I've seen a 60, 80 page.
So it's a committee bill. We're sort of referring to our committee bill and then a joint proposal. Those are the words we're using.
Okay, so I think I've certainly seen last year's and the joint proposal. And I also understand there's been some testimony over the last few days about perhaps a change from that in terms of on the record, more on the record appeals. So I will attempt to answer any questions the committee has in those regards. But as I said initially, I view my role here as trying to help the committee understand the impact on those changes on the court process. And as I said last year, even the transformation last year, which I believe my testimony was that would have a significant impact on the numbers of cases coming to the court and the workload because of the intensive nature of Act 250 appeals, the de novo appeals. But even with that significant change, it wouldn't impact the resources allocated to the judiciary because the staff and the judges are essentially embedded into the judicial process in the sense that they're already working some of their time in other divisions, or at least have come from other divisions, so their skills are transferable to other parts of the court. So under either last year's bill or the committee bill or the joint, as you call it, the joint bill, it would certainly vary the way that court operates and the workload of the court, but it would not have an impact on the resources devoted to the court. I think some of the best examples I can give you are from the most current numbers that were just put up on our website in the last day or two, and just to give you an idea of what's before the environmental court. Total cases filed this is for fiscal year 2019, 163 cases. They disposed of 185 cases in that year, and there's 72 still pending. We refer to, when we're looking at the number of cases coming in versus those disposed, we refer to that as a clearance rate. And any time we're achieving a clearance rate of 100%, that means obviously we're disposing of as many cases coming in. What's significant for me and the administration in the courts, when that number exceeds 100%, and in this past year it did, and it has consistently over the years, over the last 5 years, a clearance rate of 118%, 117, 103, 102, and this year 113. The significance is that means not only are we disposing of cases coming in, but we're not building up any backlog. In other words, cases are not piling up. And quite frankly, this division probably has a better record clearance rate than most of our other divisions. It's probably one of, if not our most efficient division in that regard. And I think that's important for the committee to understand with the issues that you're grappling with. One of the bills, perhaps more than one, talked about the Act 250 appeals. And those can be extremely labor intensive. For the last year, the total of Act 250 appeals and A&R de novo appeals, according to the record numbers I have, are 21. Of that 21 cases, only 8 were Act 250 appeals. The others are made up of jurisdictional opinions as well as the A&R de novo appeals. The other, at the present time, there are very few cases on the record appeals. There are only 6, and that number has pretty much been the average over the last 5 years, because they're coming from the municipalities, and very few of the municipalities are engaging on the record. So that's why that number is so low. But in addition to the clearance rate, which I think is important for the committee, I think the other issue that is important is how long it takes for these cases to be processed once they're in the system. And I know you've heard testimony from people who said that's a major complaint. We have, when the environmental court was set up, we have established internally guidelines for processing of all of these different forms of appeals through the system. And by that I mean we have guidelines for what we refer to as a standard matter, complex matters, and we even have guidelines for on-the-record appeals. Though we have more than that, but these are the ones that I think have interested the committee. And clearly the on-record appeals are set up, the guidelines that are set up are at much less time than the de novo appeals. It goes without saying. The progress of those cases of all kinds through the system, in less than a year, over 80% of our cases are resolved in less than a year. I think that's a pretty significant number, regardless of what type of appeal you're looking at. If you're looking at on-the-record appeals, now it's difficult because there's such a low number. But over 80% of all the cases are resolved in less than a year. And I think it's because of these guidelines have been established, and the judges adhere to those guidelines and are aware of them. So I mean, that's just an overview of what the numbers are this year, and I'm glad to answer any questions that committee members may have. I know you've talked about on the record appeals and what that may mean, and I'm glad to, even though it's not part of the bill right now, I understand there's been testimony, and I'm glad to try to answer any questions.
Representative Morgan.
And you said there were 21 appeals to Act 250 last year?
I have, this is from our webpage, it's listed as Act 250 appeals and A&R de novo appeals, 21. And A&R, yes.
Yeah, someone gave us the breakdown somewhere recently on that. Yeah.
So there were actually less than 21 250.
I have the number, and this didn't come off our website, so I want to verify it for you, but in talking with the environmental division folks, according to fiscal year 2019, they said they had 8 Act 250 appeals. The year before, fiscal year 18, it looks like they had 13 Act 250 appeals.
I thought you said 8 were jurisdictional opinions.
No, I have it down as 4 were jurisdictional opinions in addition to the 8.
Oh, 8 appeals and then plus 4
jurisdictional. And the rest, I assume, would be then the A&R.
Representative Lafayette.
These 8 appeals, they were to the environmental court or the
Yeah.
Supreme Court? Any
No.
in the Supreme Court?
No, these were to the division, to the Superior Court division, to the trial court level. And I'm not sure, I can get that number if you're interested in knowing how many of those cases went from Superior Court, if you will, Environmental Court, appeal to the Supreme Court, if you're interested in that. I recall from my testimony last year, that the percentage of cases that go from Environmental Court to the Supreme Court is relatively small, but the appeal, lack of a better term, by far most of the appeals are upheld. There's very few. I think the numbers I gave you last year were out of maybe 200 appeals filed over a significant period of time. Only 15 went back to the trial court. And sometimes they go back not because the decision itself is wrong. It may be what's referred to as a remand of a case for the trial court to make additional findings to support the decision they've made. So not every appeal is I hate to use the term win or lose, but it's not always that. It sometimes can be, we need to add more, make additional findings if you can. If you can't, then you can't.
The judges who sit on the environmental court, are they given special training, or how does, if one would retire, one was to retire next week, how would that be, how would they replace it? How would they replace it?
If one retired next week, obviously we'd go through a recruiting process, and anyone who that seat would be designated as an environmental seat, and we'd certainly be looking for someone who came in with experience in that field. I can't tell you exactly what their background was of the two, for instance, that are sitting now, but in talking with them over the last few days, since the bill has been under discussion, I know both of them appeared before district commissions. I think one was a district commissioner, and so both of the current judges had extensive experience in that field before they were appointed judges. And I would expect if one of them were to retire, we'd be looking in the same vein. But, and again, I can get their complete background for you, but I know that they've had extensive experience.
Representative Morgan.
And you said there were two. You have two.
There's two now, yes.
Other questions for Representative McCullough?
Judge, if we take as an assumption that the district commissions are going to be beefed up and produce satisfactory on-the-record results, then what might be the ramifications of those cases should they become appealed going directly to the Supreme Court? I think we understand skipping a step is quicker, but what might be pros and cons of that?
So let me answer that by asking you, I want to make sure I understand the question. Are you talking about, obviously, the district commission being the entity that hears the case,
Yes.
hears the facts, makes the decision? Are you talking about a on-the-record appeal of that decision to the environmental division or straight to the Supreme Court?
Yes, an on-the-record appeal
From the district?
From the district. They created the record at the district in that trial, if you will. And what would be the ramifications of going directly to the Supreme Court, other than the obvious, we've skipped a step and it might be quicker?
It would definitely be quicker if you skip that step.
Right.
But the issue on an on-the-record appeal is that obviously in the time that this committee is devoted to looking at the existing structure, this is a complicated area of the law, both factually and legally. So the record, whether it's on record appeal to the environmental division or to the Supreme Court, you're going to have to provide the district commissions with professional expertise they need to address these issues. And somebody will have to have the expertise to make rulings on what evidence is going to be considered. And it's going to require a process or procedures with someone to make those rulings. I don't think you're looking at a situation where you're just going to open the door and have anybody and everybody who wants to be heard on a particular project. Somebody has got to set the
Right.
process and procedures.
Right.
And then somebody has got to have the training, education, skills to make those decisions, because that record on appeal is only as good as the
That's right.
support that the district commission has.
Right.
It's like, if you think of, that we're hearing those cases now on a de novo basis.
Right.
If you think of that as the bubble that you're looking at, of witnesses and process and procedure, you're moving that bubble further upstream to the beginning of the process at the district commission level.
Right.
But it's the same issues.
It's the same issue.
And the same facts.
Yeah.
Somebody has got to decide what is appropriate, both legally and factually, for that commission
Right.
to make a decision that will be upheld by the Supreme Court. And so that record
All important.
is critical.
Yeah.
I mean, it's only as good as the resources that you put into it. There's not a way to cut corners.
Given all of that, if it wa- and skipping the E-court with the on the record appeal and going directly to the Supreme Court, you did talk about remand and often, or sometimes back to the body.
Yes.
Would it be, would you say it'd be important to not skip the E-court and have the E-court make the decision based on the record that they received before it went to the Supreme Court, because they might discover a need to remand it back to the body, or just, so I'm trying to suss out whether we can, if we have, we're just gonna assume a quality record got created. I think we have to assume that, because if we're not looking for that as a result, then none of the rest works.
That's right.
So we're assuming a quality result, and I think the development community, and I think many advocates will find that one less step would be advantageous. But I'm wondering, I mean, that's from their perspective. I'm wondering from the judicial perspective, if, yeah, that might look good, Representative McCullough, but the pitfall is, by avoiding the E-court, the pitfall is blank.
So, Representative McCullough, I would love to be able to answer that question for you, but I'm afraid that that's where I have to draw the line between policy and impact on the courts. And if I ventured into that territory, I would be in a lot of trouble.
I wouldn't
that's
want
not,
you to be in trouble.
well, that's not my role, and I
Yeah.
understand the question, I understand the concern, but I think that's something the committee really has to look at when they're considering a change from the current system. And I'm not here to advocate.
Right, no, yeah.
Keep it the way it is.
That's not
That's
your
what the
role.
committee has to decide, and I wouldn't venture a response to that question.
Well,
but it's
multi-level
a question
marketing.
the committee has to ask.
The multi-level marketing would say, if not you, then who? Who or what department might you suggest we query in that one?
I think what the committee has seen over the last year and beginning this year are any person who's in this chair, you have to ask yourself, what is their interest in the outcome? And you have to consider that in whatever testimony they're
Absolutely.
giving. So to answer the question as who you should get that from, I think you need to get as much input as you can. That's the only way that you're gonna be able to answer that question for yourself.
All right.
And you have to judge the value, the weight of whatever the witness says.
Thank you very much.
All right, other questions?
I have.
Judge Grearson?
This proposed process at the district level could also become very time consuming too, couldn't it?
Sure. Sure, I mean, that's what I'm saying. You're considering the same issues
Just at a lower level.
earlier in
so
the
to
process.
speak.
And so I can't tell you whether it's gonna take more time, less time.
But it may not be a time saver.
Well, we would be eliminating the double, because right now it's happening at the district commission anyway, and then if it gets appealed, it's happening again. So we would, I would think by
You know,
definition,
no
find
bias.
some savings.
Right.
It's getting
Yes.
heard, yes, it's getting heard now, so if you go on the record, you're eliminating that piece if you're going to the environmental.
And if it gets appealed, yeah. Okay, other questions? Thank you so much for taking the time to come in.
I would be glad to come back as the committee gets further along with the specific bill and offer any.
All right.
Thank you very much for inviting me.